and thanks to LAC for hosting this event. We always enjoy partnering with LAC. I'm Eric Sapp. I'm a staff attorney at Legal Services for Prisoners with Children. LSPC is a support center. We do trainings such as this and on many very different topics, and unlike this one, we do technical assistance, and especially if you are or work for a qualified legal services project or qualified legal services provider in California, you can ask LSPC for technical assistance on legal matters. That could be research, it could be advice on a specific angle on a case that you're working on. It can be anything related to the provision of legal services to indigent persons in California. We also do advocacy support at the legislative level, at the administrative level, and select impact litigation. So feel free to reach out to us for those support center services. I'll pass it over briefly to my colleague, Alissa, to introduce herself, and then I'll give a presentation and then kick it back to her for her remarks, and then we'll have a Q&A at the end, and feel free to put questions in the chat or Q&A function throughout. Alissa?
Hi, I'm Alissa Moore with Legal Services for Prisoners with Children. All of us are none. I'm formerly incarcerated. I served 25 years on the inside. So as you can imagine, I'm very excited about Prop 17, and with the recent election, really excited about getting more people that have been previously disenfranchised familiar with the voting process and the political power that we now hold.
Thanks. So sort of the structure of this is going to be, I'm going to be talking about the Richardson versus Ramirez decision from 50 years ago. That was decided by the U.S. Supreme Court, and I'm going to talk about some of the briefly about a few other cases from just before that era, and I'm also going to talk about how a few philosophical ways of interpreting might shed some light on what happens in that case. And then I'm going to kick it over to Alissa, and she's going to talk about Prop 17, as she just mentioned, which removed the disenfranchisement of persons on parole from the California Constitution. So that will bring us up to the present, more or less, in terms of the shape of the California constitutional right to vote in the state of California. And those of you who are not in California, if there's anyone watching from afar, hopefully this will be interesting to you as well, both from a comparative state perspective and from a federal constitutional interpretation perspective. So please, provide feedback and comments. So I'm going to share my screen. Okay. So this case brings us back to an era of American culture in the 1970s, sort of a turning point, you might say, in the Supreme Court's makeup. The Warren Court era of the 50s and 60s, known as the more progressive. The more progressive era, maybe the most progressive era in U.S. constitutional history, had come to a close, and a new what's sometimes called conservative or right-wing backlash had kicked into gear in the mid-70s, and up to the present, which some would say has intensified. Now, Richardson versus Ramirez had to do with an interpretation of the 14th Amendment, and the original plaintiffs in that case had tried to bring an equal protection challenge to the denial of voting rights for persons who had completed parole, had been convicted of felonies, had served their sentences, had completed parole and were off parole, but were still denied in 3 counties in the United States, in California. Ultimately, those counties ended up changing course and agreeing to allow those 3 individuals to register, but they were suing as a class and also suing the defendants as a class, meaning all the counties. And so a different county ended up coming to take the place of the defendants and in the role of petitioner in the Supreme Court, because the plaintiffs had won at the state level. So the key part of the 14th Amendment that the respondents, that is the original plaintiffs, had wanted to use to support their claims was the Equal Protection Clause, which in the relevant part, nor shall any state deny to any person within its jurisdiction the equal protection of the laws. This was passed just after the Civil War, ratified in 1868. I will come back to that in a moment, but just setting some of the immediate or the Warren Court era relevant landmark cases in the general vicinity of equal protection for voting rights. Reynolds v. Sims in 1964 found that Alabama's apportionment of state legislature districts was a violation of equal protection because it had vastly unequal populations within different districts because they were allocated by county. And that essentially meant that there was greater representation, for example, for like white rural counties versus more densely populated and more racially diverse urban counties, for example. The case a year later in 1965, Carrington versus Rash had found equal protection violation where Texas had denied the ability to register to vote to a member of the armed forces who was living in Texas, although he actually worked across the border in New Mexico, across the state border. And they had a rule that said you could not, basically register in Texas under those circumstances. That was found to be an equal protection violation by the Supreme Court. Before the Ramirez, Richardson versus Ramirez case in California, at the California Supreme Court, a major case in 1966 was Otsuka versus Haidt. This was a case where the plaintiffs had been conscientious objectors during the Second World War and were disenfranchised for refusing, they didn't have their objector status recognized, and so they were actually convicted for refusing to enlist and were disenfranchised on that basis. The Supreme Court of the state, under the then existing state constitution, which is no longer the current one, and was had also been changed by the time Richardson versus Ramirez. But at the time, the state Supreme Court, the state constitution of California disenfranchised someone for conviction of an infamous crime. And if you are able to see the shared screen, you have the text of what was then Section 1 of Article 2 of the California Constitution, that in relevant part says person convicted of any infamous crime shall ever exercise the privilege of an elector in this state. And you can see, and I won't read out some of the other categories that were disenfranchised. But the current California Constitution, Article 2, Section 2, and Section 4, which is included in the supplementary materials that are accompany this webinar. You can read the current California Constitution. It no longer speaks of an insane person, etc., but rather talks about someone who's been adjudicated mentally incompetent by a court. So there is the equivalent of that particular grounds of disenfranchisement, and of course, persons currently serving a prison term in state or federal prison are currently disenfranchised in California today, but not a mere status of conviction anymore. So Richardson versus Ramirez, as I said before, so by the time the case reached the Supreme Court, there had been the Constitution. I mean, between the Otsuka decision and Richardson versus Ramirez, there had been a change to the California Constitution, but again, person convicted of an infamous crime was a disqualifying category. And again, the plaintiffs had won a favorable decision at the California Supreme Court in 1973, just before that was appealed to the U.S. Supreme Court. So Mr. Ramirez was denied the right to vote in San Luis Obispo on account of a 2 decades old robbery conviction in Texas. He had served 3 months in jail and then a little under a decade on parole, but that was completed a decade before the attempt to register. Mr. Lee was convicted of heroin possession in California and had paroled in 59 and in Monterey. And lastly, Mr. Gill had been convicted of burglary and forgery and was denied the right to vote in Stanislaus County. Now, all 3 of those ended up giving them the right to vote. I mean, ended up, voluntarily changing their policy and allowing persons in those categories to vote. But there were other counties that still had a practice, and one was Mendocino, which jumped in to take the role of petitioner at the Supreme Court level. So as a procedural and jurisdictional matter, the court first had to find that the case wasn't moot on account of the named plaintiffs having been granted the ability to register, and the majority on the class basis, both for the plaintiffs and representatives, found that there was still a live controversy, and so the case was properly before them. In the dissent, Marshall disagreed with that, or disagreed with at least the appropriateness of the procedural reaching of the merits that the majority had, because as he stated in the dissent, the plaintiffs didn't get the relief they sought. The court denied the writ. They basically just got a declaratory judgment, and but this is not the position that the majority took. So going back to the majority, so they said that unlike most claims under the Equal Protection Clause, For the decision in which we have only the language of the clause itself as embodied in the 14th Amendment, respondent's claim implicates not merely the language of the Equal Protection Clause of Section 1 of the 14th Amendment, but also the provisions of the less familiar Section 2 of the amendment. It's a methodologically what the majority does, and again, this was authored by Justice Rehnquist. What the majority does is an interpretation based on the classic non-precedential or non-doctrinal factors of text history and structure. This is you could say a sort of formalist approach to constitutional interpretation, one that did not rely too heavily on the interpretation of precedents, but rather attempted a direct construction of the text, and doing so in an intra-textualist manner that is not focusing on the clause, the Equal Protection Clause itself, but rather seeing the relationship between different provisions of the Constitution, in this case, different sections of the 14th Amendment. So that's a intra-textualist sort of form of textualism, combined with an approach to history which is highly questionable, and the dissent definitely takes issue with the reading of history that ends up being adopted by the majority. So Section 2 of the 14th Amendment is on your screen. Again, these slides will be made available to everyone who's registered for this webinar. Section 2 of the amendment, in relevant part, says that when the right to vote for various offices, including federal and state offices, is denied to any of the male inhabitants of such a state, or in any way abridged except for participation in rebellion or other crime, the basis of representation therein shall be reduced. So what is going on here is that the calculation of representatives is tied to the extent of suffrage. And of course, this is before the constitutional protection of the right to vote for women, which is why it is premised on male inhabitants, which wouldn't be secured in the federal constitution for another half a century. And the key clause within section 2 is except for participation in rebellion or other crime. Now, everyone agreed that the reference to rebellion is intended to capture the status of persons who had participated in the Civil War on the side of the Confederacy, and that disenfranchisement of someone who was disenfranchised in a particular state on account of having participated in rebellion would not be their disenfranchisement would not go toward reducing the representation of that state. Whereas if someone is disenfranchised for another rationale, such as on account of their race, the representation of that state would be reduced. And then sections 3, 4, and 5, I'm just putting this here for the broader context, although they're not referred to at all in the case. Section 3 has to do with the disqualification for or I should say, they're not mentioned in the case, although they do have some potential relevance as unmentioned implications. Section 3 disqualifies those who have engaged in insurrection or rebellion, or given aid or comfort to the enemies of the United States, unless the disability of serving office is removed by Congress. Here, the phrase rebellion occurs again, and it occurs in tandem with insurrection and giving aid or comfort to enemies thereof. It does not have the general reference to other crime as in section 2. And then sections 4 and 5 are also here. Section 4 again talks about suppressing insurrection or rebellion, and section 5 is about enforcement. So one could say that now it would be a possible way of reading section 2 and 3 together to say that the other crime mentioned in section 2 is just a shorter form of saying what is spelled out in section 3 as insurrection or rebellion or aid and comfort to the enemy. But that's not the approach taken by Justice Rehnquist and the rest of the majority. Okay. Now, this on the screen right now is a passage from the Rehnquist's opinion, and I quote. I'll read it out. Quote: petitioner, that is that's the Mendocino County, contends that the italicized language of section 2, what was italicized by the court, expressly exempts from the sanction of that section disenfranchisement grounded on prior conviction of a felony. She goes on to argue that those who framed and adopted the 14th Amendment could not have intended to prohibit outright in section 1 of that amendment, that is the Equal Protection Clause, that which was expressly exempted from the lesser sanction of reduced representation imposed by section 2 of the amendment. This argument seems to us a persuasive one, unless it can be shown that the language of section 2, except for participation in rebellion or other crime, was intended to have a different meaning than would appear from its face. Now, this is interesting, that here rhetorically, Justice Rehnquist is suggesting that on its face it has a clear meaning, whereas in the oral argument, which took place earlier I believe in January of 74, the unclarity of the meaning of other crime, whether it was specifically tied to the Civil War Confederacy rebellion context, that is other crimes committed in the context of that rebellion, or if it was a general clause referring to any crimes, or some other reading narrower than the latter, but wider than the former, such as like infamous crime, as we saw was the phrase used in the California Constitution at the time. That was something that the respondent's attorney pointed out. Mr. Glick pointed out that there was the familiarity with the language of infamous crime even existed in the 19th century, and so had Congress decided to include, for example, felonies or some subclass of felonies, such as those that in 1966, the California Supreme Court found evinced moral corruption sufficient to enable disenfranchisement to be state constitutionally sound. Congress could have used language like infamous crime rather than other crime. And so the respondents' argument was that in this context, the other crime is to be read as having its meaning partly determined or mainly determined by participation in rebellion. But leaving that aside, so the logic of this reading of Section 1 and Section 2 of the 14th Amendment together depends, here on a logical gap, which is sort of allowed, which has a semblance of coherence due to a loose way of understanding what here Rehnquist calls as the sanctions of the two sections. So in the case of the first section of the 14th Amendment, the person themselves is being provided with equal protection, and whatever remedies are associated with that are remedies that go to the benefit of that person, at least. Whereas in Section 2, the sanction of reduced representation is not first and foremost something suffered by it is something suffered by the state, and not because in the case of the Second Amendment, like the goal was for those not to deter those states that had disenfranchised persons who had participated in the Confederacy or fought on the side of the Confederacy or did other acts supporting the Confederacy, not to deter states from disenfranchising them, but at the same time incentivizing those states to enfranchise freed enslaved persons, formerly enslaved persons who had been freed on account of emancipation. And so and this is the historical argument that it was put forth by the respondents, and is also agreed to by the dissenters for the court. What Congress was trying to do with the second section, that part of the second section, was not displace this Reconstruction sort of compromise, while at the same time providing for a penalty for any state that would disenfranchise freed slaves, because this was prior to the adoption of the 15th Amendment. 15th Amendment was adopted 2 years later, and that said that that racial, on the account of race, color, or previous condition of servitude, Congress, the right of citizens of the United States to vote shall not be denied or abridged. And so, but that was not in place at the time of the 14th Amendment. So, Justice Rehnquist continues in the opinion, the problem of interpreting the intention of a constitutional provision is, as countless cases of this court recognize, a difficult one. Not only are there deliberations of congressional committees and floor debates but an amendment must thereafter be ratified by the necessary number of states. Legislative history bearing on the meaning of the relevant language of Section 2 is scant. The framers were primarily concerned with the effect of reduced representation on the states, rather than with the two forms of disenfranchisement, which were exempted from that consequence by the language with which we are concerned here. Nonetheless, what legislative history there is indicates that the language was intended by Congress to mean what it says. So here, basically both of the arguments just laid out are contained in this one paragraph. Rehnquist is sort of almost conceding that the concern, that the intention of the Second Amendment is not about well, he basically concedes that there's very little evidence of the historical intent, and then he pieces together from very meager historical documentation a few interpretations that support the wide reading of other crime in that section. So one example of that, and this was from 1866, is a representative from Ohio, Eckley, who gives this very inflammatory rhetorical speech, which imagines a mass of pirates, counterfeiters, or other criminals who would be given an opportunity to land their piratical crafts and come on shore to assist in the election of a president or members of Congress. And that then points out that is this Representative Eckley from Ohio, that he's imagining only property crimes, and then making a kind of further a fortiori type of argument that treason is a much more serious crime. So he's supporting the gist of this argument is to support the legality of disenfranchising on the basis of rebellion, and here he's including certainly treason as another crime in the same vicinity, but does so on the premise that crimes like piracy or counterfeit are also appropriate for disenfranchisement. But that is, that doesn't, prove that premise. He just, Eckley just kind of takes that as a rhetorically plausible starting point to make his argument for the exclusion of treason, not as a reason for excluding piracy, other than the sort of intuitive reaction against that. Then apparently without irony, after explaining how the subject was not at all exhaustively covered, Rehnquist says that the Senate was not as exhaustive as the House, but it may have had some unknown, unreported caucuses off the floor that addressed the issue. And so he uses this allusion from Senator Salisbury of Delaware, who says that there was serious deliberation for days as some basis for supposing that during these unknown and unreported deliberations they were reaching the interpretation on other crime, which is relevant to the case today. It's very implausible speculation about what happened in those caucuses. Then Rehnquist goes on to cite a senator from Maryland who was an opponent of the 14th Amendment, who made an argument regarding what he called the right to be represented. And this idea, and again, this is in the context of someone opposing opposing the 14th Amendment in total, uh, saying that you know that the proposed amendment at the time would deny the right to be represented of a part simply because they are not permitted to exercise the right of voting. So the idea is that if someone is denied the right of voting, at least they're being represented by those they are not allowed to vote for, and therefore are not allowed to say that they don't want to be represented by them. And perhaps disingenuously, you know, um, makes this argument that again presupposes that a what he calls a robber or counterfeiter would not be allowed to vote, but they are at least included within the basis. That is to say that they would have their right to be represented would be included in the count of representation, and so that's a benefit that they would be getting. So the court does cite other examples from the historical record, but there's nothing that provides a particularly persuasive, let alone dispositive interpretation of the Second Amendment that the court had decided. And I think the dissent is right when it points to its alternative construction of the 14th Amendment. Sort of toward the end of the opinion, Rehnquist says that the court has never given full consideration of the precise question before it, but notes that in the late 19th century, it had approved the exclusion from voting in Utah and Idaho of persons who had been convicted of polygamy or bigamy. And ultimately, what they hold is that the state Supreme Court, in its interpretation of the Federal Equal Protection Clause, had erred, and that, however, it still left open that because there was lack of uniformity across the counties in terms of what they counted, in terms of how the counties applied state eligibility law, that could still be an equal protection violation. So it remanded it back to the states. I encourage, I'll skip over the dissent, but I encourage everyone to check out Marshall's opinion, which is very interesting. That's included in the materials. And I'll just say a few more words about the irony of the concept of disenfranchisement. So there's two alternative ways of tracing the etymology of franchise, and they both lead back to an idea of being free. The first etymology here, and this is on Wiktionary, traces it back through Old French franchise as a derivative of franc, free, and the second goes back to franchir, to set free, ultimately also from franc, free. Now, I checked this against a French dictionary and from the uh, National Center in France on textual and lexical resources on that, pretty much checks out that, to liberate or render free is the ultimate etymological source for the term franchise, which, takes on a whole bunch of different senses in legal contexts, including, the franchise of municipal functions or of businesses, but most importantly for the exercise of voting rights. But I think it's interesting to recognize that the original sense of this word is related to the idea of freedom. And just a quick I'll come back to the other term in the title, deconstruction. I'll come back to that and how that bears on this case. If there's time during the Q&A, if anyone's interested, I encourage you to ask that, and we'll come back to that term in a moment. But for now, I'll kick it back over to Alissa, who's going to talk about Prop 17 and related matters.
I'm having technical troubles. I'm trying to get my camera on. But in lieu of that, I'll go ahead and start with Prop 17 and the fact that in 2020, it has passed. Well, obviously in 2020, the right was restored to vote to formerly incarcerated people that are currently on parole and so forth in the state of California. I myself, when I came home from prison, I was, under the impression that we weren't allowed to vote. I didn't have a lot of political knowledge of, the voting process and what had happened and transpired while I was incarcerated. And that's not much different from individuals like myself that come from incarceration. Many of us don't realize that the right to vote was restored, and we realized this when we were working on Proposition 6, that was first ACA 3, then 8, and then finally became Proposition 6. While we were doing outreach, we realized that many individuals that were formerly incarcerated did not realize that the right had been restored. And then further, I've been an Alameda County Elections Commissioner. We've realized that there hasn't been state, local, or federal monies devoted specifically to political education for people that, have previously been disenfranchised. Ironically, I am a native of Mendocino County, so it was crazy to hear Eric discussing, the petition, their involvement in previous, events leading up to this. So I think that it's really important for those of us that are formerly incarcerated to, embrace the power that we now have in Prop 17 passing and having the right to vote, realizing that, we've had insurmountable odds against us restoring this right. And just the fact that we've won this right back in California, I think that, so California goes, hopefully the nation does as well. And everyone that is formerly incarcerated across our country will eventually be able to vote. But part of that is, political education and awareness of the political climate that it is, because as we've seen with Prop 6 failing as it did on a California ballot, is crazy. It passed in Nevada, and we would think that it would have passed here if it would have passed anywhere. But that's really just not the case, because we are having low registration and really low education in the area when it comes to, people that are formerly incarcerated, and just people in general realizing that this has passed and that we have been re-enfranchised. But my personal belief as a elections commissioner, and also just my personal belief, is that like without investing in this area heavily, in the education and political education, particularly, we've restored the right to vote, in ink only, and that gets us nowhere. So I don't know, who's on the call or who has the power to mobilize and educate it in this specific demographic that's watching. But I hope that anybody that is would, put this at the forefront of their, measures that they push within their personal lives and with their organizations, and really just talk about it. Having these types of conversation is essential, because we really don't know where they lead to. I always talk about the power of seven, and the fact that, within 7 degrees, there is somebody that is listening, that knows someone that could possibly, be the one to push this issue to the forefront, or mobilize in a major way, or devote certain dollars to this type of education. Because I myself, coming out of prison, was fairly ignorant to the fact that we even had this right, or how important it was to vote. Recently, with Prop 36 passing, and everything else that happened in this last election, I find myself realizing that the fact that we aren't mobilizing now, our children's children's children may be even paying for our mistakes and our lackadaisicalness about not being involved in the political process, on every level, not just the presidency on down, but like every level. Even, being formally incarcerated and being in a position of the being a commissioner on the Alameda County Elections Commission, and soon to be the representative for, well, the Democratic representative for Alameda County, is just, to me, is unfathomable, coming out of incarceration, that this would be an opportunity for myself, or individuals like myself in my situation, coming from incarceration. And so I find it even today, almost unbelievable that I'm in this position, and being a part of LSPC, and being able to advocate for new laws to be passed, and speak directly with assembly members and senators, and working together to make our communities a safer place, and pass no nonsense public safety measures that are cost effective and better for our community. Nobody could have ever made me believe this would be something that I would be able to, not only be a part of, but take a lead in. So I really just encourage everyone to keep having these conversations, and talk about this in every circle that they're in, because it's an extremely valuable conversation to be had, because you never know who you might be impacting, or who you might be sharing your story with, that it could really change the trajectory of their life. Because like I said, you couldn't have told me in a million years when I was incarcerated that this was where my life would lead me, or where I would be today. And you certainly couldn't have told me that being involved in the political process would lead to one of one of my most proud moments of my life, being a part of Senate Bill 1254. So I just would encourage everyone to keep having these very needed conversations when it comes to voting, and it comes to, the reenfranchisement of this population, because it's so valuable, and it contributes so much to, what we do today at LSPC. And I really just couldn't express how important it is to, have these conversations and let people know, because you might think that people would know because this passed so long ago in 2020, but that's really not the case. And it's really sad that we don't have more dollars, whether they be state, local, or federal, or private, devoted to educating this demographic, because we are so powerful by the numbers. And if we were to mobilize and invest in educating our demographic, we would probably be, the ones being courted for our vote, because our numbers are so great. And with that, I'll just pass it back to Eric.
Thanks, Alissa. Do we have any questions from the audience yet? If not, feel free to, I encourage you to ask questions. You can either raise your hand and you'll be unmuted, or you can write it in the Q&A function and we'll read it out. So no question is too easy or too difficult, and you don't have to ask questions either. You could also express observations and disagreements if you so choose. So while people are formulating that, I'm going to return to the topic of that I alluded to earlier, which is part of the subtitle of the presentation, and that's deconstructing disenfranchisement. So what did I mean by deconstructing? So this is a term used in continental philosophy in the 20th century and early 21st century, and it goes back principally to a rather arcane philosophical debate taking place across numerous books and articles, principally by two philosophers, one Heidegger and the other Derrida. Heidegger, a German philosopher, and Derrida, a French philosopher. And how this is relevant to this case, I hope to demonstrate, but I also appreciate feedback if you think this is an inaccurate interpretation. So let me share my screen once again. So this is an entry in a book edited by Mark Rathall, and this particular passage is written by Dermot Moran. He's describing Heidegger's notion of destruction, which was the basis for Derrida's notion of construction. And again, this is Moran's interpretation of Heidegger. I think it's correct. And he describes philosophy as destruction, as a, quote, becoming free from the grip of traditional handed down ontological concepts through a dismantling, leading back to a basic sense. So the idea is that our understanding of a concept, it could be a fundamental concept like the right to vote. It could be a fundamental concept like equality. In our purposes, is not we're not the concepts that Heidegger was concerned with. He was concerned with concepts like being or truth. The idea is that a tradition, which is a handing down of concepts over time and across many different persons in many different eras, builds up a way of thinking about that concept, which is diverges in important respects from the origin. So Heideggerian destruction dismantles. I think dismantling, as Moran used it here, is probably not a good word to use, because dismantling is a kind of like unclothing something. But in any event, it leads back to a basic sense of the original meaning, you might say. Similarly, again, this is from the same text. Destruction involves liberation from tradition and from common sense understanding of concepts, and it depends on an idea of tradition as inhibiting access to original sources. Now, I think this actually fits a description of what the type of originalism that Rehnquist is trying to practice aspires to do. Now, not suggesting that Rehnquist was inspired by reading continental philosophy, but nevertheless, this idea of going back to an original source is the way that constitutional originalists like to think of what they're doing when they interpret the so-called intent of the framers. Now, the term deconstruction, which has now become more popularized, was sort of given its philosophical meaning by the French philosopher Jacques Derrida, who originally thought of it as a kind of translation of Heidegger's destruction, but he had wanted to have a less of a negative meaning that would suggest demolishing something, and wanted to emphasize it more as a destructuring or a undoing of a construction, but not necessarily destroying that which is deconstructed. This is a use which, incidentally, outside of academic context, is popularized today. They're often in a culinary context, chefs will talk about deconstructed, sandwiches or whatever. And in an architectural context today, you can some architects and engineers and construction companies think of deconstruction as an alternative to demolition that doesn't destroy, say, for example, a house which is being deconstructed. The component parts might be reused and recycled in another building. Now, the key difference between Derrida's notion of deconstruction and Heidegger's is in the Derridian deconstruction, there is a skepticism about this return to an origin. In this particular text, which appears on your screen in translation, where Derrida is arguing that deconstruction is not analysis and it's not critique. It's not critique because critique passes judgment on what is criticized, and it's not analysis because, and here I'll quote, deconstruction is not analysis in particular because the dismantling of a structure is not a regression toward a simple element or toward an indissoluble origin. So the difference between Derridian deconstruction and Heideggerian destruction is precisely this idea of an origin. In the case of the Heideggerian viewpoint, there is an origin, which is the sort of basic sense of the phenomenon, whereas in the Derridian perspective, there is no origin which does not dissolve into further questions of meaning. And so in the context of our case, we could say that ultimately the problematic character of the interpretation of history that the majority puts forth displays this problem of the construction of origins. If there's no other questions, I'll kick it back over to Jocelyn to wrap things up. I'll also remind people, please fill out the survey and feel free to send any comments or ask any questions that occur to you later. I'll put my email in the chat. Thanks.